In today's news, we'll dive into the first ever post office capture conviction to be sent to the Court of Appeal. But that's not all. The CCRC itself is now facing inspection over how it handles potential miscarriages of justice. Then we will zoom out to a bigger problem shaking public trust in justice: the experts whose courtroom evidence can make or break lives. We ask, who can we really trust in the courtroom? Join us as we explore how truth gets lost in the system. Stick around and let's break it down.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Let's start with the CCRC's latest referral. On the 16th of October, the Commission confirmed it has referred the conviction of Patricia Owen to the Court of Appeal. Now, who is Patricia Owen? She was a suppers mistress who, back in the 90s, long before the Horizon IT system even existed, was prosecuted by the Post Office on 4 counts of theft. So yes, this is a pre-Horizon case, but it's still linked to the wider Post Office scandal because it centers on an earlier computer system called Capture, the software that actually came before Horizon. Although the CCRC's official referral was made on the 15th of October, the fact that they had decided to send the case to the Court of Appeal was first made public in July. That decision followed a major discovery in June, a long-lost report from a defense expert, Adrian Montague, commissioned by Miss Owen's legal team back in the 1990s. Montague's assessment was damning. He described the capture system as an accident waiting to happen and totally discredited, and contained several insidious faults not necessarily apparent to the user, faults that could easily lead to arithmetical or accounting errors. His report concluded that reasonable doubt exists as to whether any criminal offence has taken place. For reasons that remain unclear, the defence chose not to call Montague to give evidence, and the jury never saw his report. Miss Owen was subsequently convicted and given a suspended sentence. Today, according to the CCRC, 34 pre-Horizon applications have been submitted for review. Of those, we know the 4 have been refused, with the refusals signed off by a panel of 3 commissioners. The rest remain under consideration. That's why Patricia Owen's referral is such a milestone. It's the first conviction from the Post Office capture era to be sent back to the Court of Appeal, and it could open the door for many more. These cases also confirm something campaigners have long suspected: that the Post Office's internal culture, management pressure, and investigative practices were already leading to questionable prosecutions years before Horizon made everything worse. Now, if you have just joined this channel, and in case you were wondering, what exactly does the CCRC do? The Criminal Cases Review Commission is the safety net of the justice system. It's an independent body that investigates potential miscarriages of justice in England, Wales, and Northern Ireland. And if someone believes they've been wrongly convicted and has already lost their appeals, they can apply to the CCRC. If the Commission finds there is a real possibility that the conviction or sentence would not be upheld, it can refer the case back to the Court of Appeal. Sounds reassuring, right? Well, it's complicated. The CCRC was created after high-profile wrongful convictions in the 70s and 80s. But in recent years, it's been criticised by campaigners, MPs, and even former commissioners for being too cautious, too slow, and too reliant on the original evidence that led to convictions in the first place. And that brings us to our next story. On the 7th of October, the CCRC chair, Dame Vera Baird KC, announced that she has directed a full professional inspection of the Commission's casework by His Majesty's Crown Prosecution Service Inspectorate, HMCPSI. That's a pretty big move, right? It means the CCRC, the very body that reviews other decisions, is now having its own decision-making process reviewed by prosecutors' inspectors. The inspection will look at how the CCRC handles applications. This follows growing criticism that the Commission has been rejecting legitimate applications without properly understanding new expert evidence or without fully testing whether fresh information could have changed a jury's decision. Dame Vera Baird, who's only been in the role for a few months, has made transparency and reform a key focus. She's essentially saying if we expect others to be accountable, we should be too. But it also raises an important question. Is HMCPSI actually the right organisation to be inspecting the CCRC? Let's think about it for a second. The Crown Prosecution Service Inspectorate, as the name suggests, was created to oversee the Crown Prosecution Service and other prosecuting bodies. Their main job is to make sure prosecutors are following proper procedure, using evidence responsibly, and acting in the public interest. The CCRC, on the other hand, is something completely different. It's not a prosecuting body, it's an independent review commission designed to look after the justice system, not represent it. So having a prosecutorial inspectorate examine an organisation whose job is to challenge prosecutions, well, that's a bit like asking the referee to inspect the VAR team.
The sleeve, not the bare part of the arm, but what will VAR make of that?
A recommendation that the goal will be disallowed for a factual handball.
Some critics are already asking whether this creates a kind of structural bias, not necessarily deliberate, but just baked into the relationship. HMCPSI works closely with prosecutors, understands their processes, and measures performance largely from that perspective. The CCRC's job is to scrutinise the justice system, to ask whether the prosecution, the police, the court, or even HMCPSI have made mistakes, which makes it awkward, doesn't it, for the very body that could come under that scrutiny to now be inspecting the CCRC. So would it make more sense to have a separate purpose-built inspectorate for the CCRC, one that understands the specific challenges of reviewing miscarriages of justice? Imagine an independent justice review inspectorate, a small expert body focused purely on oversight of organizations like the CCRC, the Forensic Science Regulator. That kind of body could bring in perspectives from defense lawyers, forensic scientists, statisticians, and even former applicants, people who understand what's like to be on the other side of the process. Because right now there is a risk that the CCRC is being inspected by a body that, while professional and well-intentioned, ultimately comes from within the same institutional family as the organisation whose work the CCRC is meant to scrutinise. That doesn't mean HMCPSI can't do a fair job, but it does raise a question about perception. If the CCRC wants to rebuild public trust, wouldn't that trust be stronger if the inspection came from a completely separate and independent authority? Let me know in the comments below. So yes, Dame Vera Baird deserves credit for opening up the commission to inspection. That's a bold and necessary move, but it also highlights something deeper. We still don't have a clear system for holding the justice watchdogs themselves accountable in a way that's transparent, balanced, and truly independent. And that's something Parliament might need to look at next. All of these come at a moment when the criminal justice system is under increasing scrutiny amid an interesting debate about the use, or rather misuse, of so-called expert evidence in the courts. So let's talk about that. Expert evidence sounds reassuring, right? You imagine scientists, doctors, or statisticians explaining complex facts objectively to help the jury. But what happens when those experts get things wrong? Or when their methods turned out to be unreliable? That's the focus of a growing storm around expert witnesses in the UK. Recent news outlets report that several parents convicted over the deaths of their children are now appealing their convictions after serious concerns were raised about the reliability of the expert evidence used against them. The central figure in this controversy is David Mangham, one of the UK's leading experts on bone injuries in infant death cases. Mangham has reportedly referred himself to the General Medical Council after a High Court judge, Mr. Justice Keehan, accused him of having a closed mind and making a number of repeated mistakes in his analysis. That's huge because Mangham's testimony has been used in numerous criminal trials and family court hearings. If this evidence is now in doubt, that would have serious implications for past convictions. In complex trials, especially medical or scientific ones, juries often rely heavily on expert witnesses. Most jurors aren't doctors or statisticians. So when a person in a white coat or with a PhD explains something confidently, it can carry enormous weight. But if that expert turns out to be wrong or even just overconfident, it can tip the scales toward a wrongful conviction. This isn't new. We have seen similar controversies before, like the Sally Clark case in the early 2000s, where flawed statistical evidence helped convict an innocent mother of killing her babies. If you have been following our channel, you will know we have covered this topic before, particularly in this video. But what's new now is the growing recognition that the system itself doesn't properly vet experts or even tell juries key details, like how much those experts are being paid, for example. All of this came to a head at an event held on the 27th of October, organised by the All-Party Parliamentary Group on Miscarriages of Justice. The session brought together an impressive lineup of speakers. The event was chaired by Lord Edward Garnier KC, and the panel included Tom Hayes, the former city trader who was wrongfully convicted in the LIBOR rate rigging scandal, Professor Carol McCartney, a law and forensic science expert for the University of Leicester, Stephanie Davis, a former coroner's officer and death investigator, and Professor John O'Quigley, a statistician from University College London. Now, just to be transparent, we actually contacted the APPG ahead of this event to ask if we could attend. We didn't receive a response. That's not a criticism. These events are often oversubscribed, but it's worth noting. When the topic is public accountability and open discussion, it's important that as many voices as possible are included. We'll keep reaching out because these conversations matter and they shouldn't just happen behind Westminster doors. From what has been shared publicly, the session itself sounded incredibly valuable and came amid growing scrutiny of the role of experts after the post office scandal and controversy over the conviction of nurse Lucy Lebby, says the Law Gazette. The discussion focused on how expert evidence meant to help find the truth can sometimes mislead courts, confuse juries, and entrench miscarriages of justice. Tom Hayes spoke powerfully about his own experience, how complex financial data was misinterpreted, and how so-called expert analysis was treated as fact without question. He said, in my opinion, one thing that should be disclosed to the jury, and I don't think I've ever heard anyone actually recommend this, is how often an expert has been instructed by both sides. So if an expert has been instructed 30 times by the prosecution, then the jury should know that. The jury should also know how much they have been paid. Stephanie Davis, former senior coroner's officer, inquisitorial death investigator and death scene interpreter, said an inquisitorial approach to cases would work better than the current adversarial system. The takeaway from that APPG event was pretty stark. We need stronger standards for expert witnesses, better education for juries, and more willingness from appeal courts to re-examine questionable science. These aren't just technical debates. They are about people's life, families, and freedom. So let's connect the dots. You've got the CCRC under pressure for being too slow or too cautious. You've got the post office scandal, whether under Capture or Horizon, where hundreds of innocent suppers masters were branded thieves. And now you've got expert witnesses under scrutiny for potentially misleading courts. What ties all of this together is a systemic caution. Institutions that prioritize protecting themselves over protecting people. The CCRC was set up to stop miscarriages of justice from repeating, but it's been criticised for acting like another layer of bureaucracy instead of a force for change. Meanwhile, the justice system still struggles to admit when it's wrong. It took years and a public inquiry for the post office scandal to be properly recognised. And even now, hundreds of victims are still waiting for compensation or exoneration. So what happens next? Well, first, the Court of Appeal will review Patricia Owen's case. If the conviction is quashed, it could open the floodgates for other pre-horizon applications waiting in line. Second, the CPS Inspectorate's inspection of the CCRC is expected to report in January. That review will likely publish recommendations on how the Commission can improve its case handling and communication with applicants. And finally, the APPG's findings are expected to feed into ongoing parliamentary discussions about reforming the use of expert evidence in court. All of these developments point to one central question: how much trust do we have left in the justice system? Because trust isn't just about courts or judges, it's about fairness, transparency, and willingness to fix mistakes. When institutions close ranks, people lose faith. When experts act like they can't be challenged, people lose faith. And when people like Patricia Owen or Tom Hayes have to fight for decades to be believed, the system stops looking like justice at all. The hope is that this moment, with the post office cases, the expert evidence debates, and the CCRC's on inspection, becomes a turning point. That we finally move from protecting institutions to protecting people. But that depends on whether those in power truly listen and act. We'll continue following each of these stories closely, and if you want to stay updated on the post office inquiry, the CCRC reviews, and the justice reform more broadly, make sure you are subscribed and let us have your comments on the issues we have discussed today. Join us again as we sit and rise in this unique trial.